So on the record on cause number DC 1717249, Elizabeth Martinez versus Al Pasano, Northwest Highway Inc. Counsel, make your appearance.
Ori Raphael on behalf of the plaintiff.
Michael Pema and Danielle Holland on behalf of El Paisano, Northwest Highway Inc., Your Honor.
All right, we're hearing a very serious motion for sanctions.
Has Your Honor read both motions and the response?
I don't think I've seen the response. When did you file it?
I filed it, I believe, on Tuesday, and I saw that it was accepted.
Okay, let me double check. Well, let's go ahead and proceed.
May it please the court. Your Honor, in brief, this is an incident that occurred in August 2017. If I may share my screen just to show you a brief 10-second video so you can see what this is regarding.
Okay. Let me go ahead and enable that.
If you see here, Your Honor, this is a video of what occurred directly after the incident. That is my client on the ground there, handcuffed and with her face wet. She was in a restaurant, was escorted out physically by a security guard who then lifted her up and body slammed her, handcuffed her, and then pepper sprayed her in the face. We filed suit on this case in December of 2017. We've been having ongoing discovery, and as you're aware, Your Honor, in March of 2020 this year, we discovered that the vital witness that the owner of the restaurant and the corporate rep, Victoria Salazar, was found after just years of saying they don't know where she is. It turns out the defendant, El Paisano, was suing her all this time and was fully aware she had an attorney. In short, we found Ms. Salazar. We deposed Ms. Salazar under the court orders. And it turns out after deposing Ms. Salazar, she is not that vital witness, but there's actually two more missing vital witnesses in this case. One is Dora Figueroa, who worked at El Paisano's in 2017 and 2018, who has never, until this day, been identified in RFDs or ROGs, as well as Daniela Artica or Ortega, I don't know if I'm pronouncing it correctly, who also worked there in 2017 and 2018, who was only disclosed in July of 2019, over a year and a half after commencement of this lawsuit. All three of these individuals, of course, one we've found worked for the defendant for over a year of litigation, yet were never identified until after they left. And after they left, defendant told us until February of 2020, or I'm sorry, March of 2020, they had no way of knowing where they were, no way of identifying or contacting them. And as I said, we found Miss Salazar, who also testified that she was not the manager of 2011 Lombardi, the place where this occurred, but the manager of the next door restaurant to 2903 Lombardi. And Victoria Salazar, also know that, admits in her own deposition that she brought evidence to El Paisano's attorney, Mr. Pema, to his office. She was still working there at the time when this suit commenced and when discovery was ongoing for over a year. And if I can share my screen again, I could show you, Your Honor. Page, apologize, let me. Here, Mr. Payne was questioning Ms. Salazar, where he says, so you may have come to my office and met one of my secretaries, correct? This was to deliver some papers that maybe we asked Griselda, the owner of the restaurant, to bring to our office, correct? So just again, for the record, that Ms. Salazar, this vital witness, was involved in actually working there at the time when this suit was in action and discovery was ongoing. Furthermore, Dora Figueroa has never been identified in any disclosures, none whatsoever, nor ROGs, responses to interrogatories. She, under Ms. Salazar's deposition, was the one who actually hired the security guard. And so that's what's vital to this case. We need to know who brought in these security guards and then who gave the order. Ms. Salazar does not know who the cashier was the night of the event who told the security guard to physically remove my client and assault her. So it's either between Dora Figueroa, who's never been identified, or Daniela Artica. She was identified in July of 2019, and defendants stated in their interrogatories that they still, she's no longer employed by defendant, and they will provide contact information shortly. Then in 2025 or February 2020, they say again, they do not have her contact information of the former employees. So I reiterate, she was working for the defendants for 2 years. This is a serious matter where we needed the witnesses and to know who saw this event. And only until recently do we find the contact is no longer there, even though they work there, when we could have stopped wasting so much time looking for these individuals. But it does get actually worse. I hate to say this, Your Honor. Not only that, they told us her name is Daniela Artica with 2 L's. If I may share my screen again. They kept telling us Daniela Artica with 2 L's. But then, I apologize, let me pull it up here. In defendant's own response, they call her Daniela Ortega. They call her Daniela Ortega, but then one more thing to share. In her W-2s, her name is actually spelled with 1 L. So again, I'm led on a wild goose chase to find a person whose name is misspelled or not identified clearly. And then they tell me for 2.5 years that they don't even know where she is, when they've had her address even in 2018, and they should have had her contact information because she was working for them a 1.5 years after discovery commenced. But even more so, we still don't even know who exactly was the night manager, because I repeat, all 3 of these individuals work there and they never identified it. Furthermore, in defendant's reply, they talk about the fact that now both 2903 and 2911 are the same company under the same umbrella. And that is in defendant's argument here, and I can show you on page 9.
We don't dispute that, Your Honor.
Thank you. He does, but he does dispute that, Your Honor. Why do I say that? They're saying here that it's the same company, same legal entity. But in the deposition of the corporate representative, Diana Murillo, she's asked 2903, 2911 Lombardi, 1478 West Spring. Mr. Pema interjects, just a point of clarification, so we don't mislead, they're under different corporations, so we may not know that they're different legal entities. All right, and I respond, are you aware that they're 4 legal entities? And she responds, yes. So which restaurant are we here for today? El Paisano being sued, do you know? 2911 Lombardi. What's the difference with 2911? It's 2 locations. Are they next door to each other? I'm almost done. It's not the same owner. It's not. It has nothing to do with one another restaurant. So it doesn't have the same staff? No. I have my staff and my other people at 2903. Why do I bring that up, Your Honor? Again, Ms. Salazar worked for 2903. This event occurred at 2911. And for 2 years, we've been told they're all separate organizations, separate things. You can't touch the other one. And it goes to the last point, which you ordered the defendants to provide the insurance from 2911. If I may share my screen one more time. Mr. Pema identified in March after our hearing, he mistakenly left out the current insurance. He informs me that he asked for any information, previous insurance, and the girl who answered the phone said they did not have such information. So I said there's no copy of any policy or any policies for that matter. I've been on a wild goose chase, Your Honor, for almost 3 years, searching for information, searching for witnesses, being told there isn't any, pretty much being lied to. Ms. Griselda Ramirez, like we learned in March, and her daughter, the corporate representative, both said everything was on Ms. Salazar. Ms. Salazar was deposed. She said she wasn't even a nighttime manager. She didn't hire security and worked at 2903 and did some work in 2008 and 9 for 2911. If I haven't been practicing long, Your Honor, but if I don't know what would cause such sanctions, I think this is it. It's costed my firm and me lots of time, money, and wasted effort when we could have just interviewed the main witness within a year of this incident. And we've just been struggling and struggling, and we only found Ms. Salazar after we were supposed to go to trial earlier this year. And I don't know how many more people I need to find and run after, but it's fairly egregious. And it seems that the defendants knew about these individuals, never disclosed them to us, never told us their contact information, and have been caught sort of in a long amount of discovery showing that it's just a web of lies and deceit that's why we bring this motion for you today, to ask for death penalty sanctions against the defendant.
May I respond, Your Honor? Your Honor, on March the 6th, we had a hearing before you and the court issued an order. And in that third motion for sanctions, Mr. Raphael incorporated his first and second motions, and the court made a ruling. What you have here right now is Miss Salazar. Let me just get my thoughts, because he was all over the place. Miss Salazar was the manager of the store, and I can go through the deposition because he only, and I'm sorry if I'm losing my temper because this is a direct attack on me, so I apologize to the court and to Mr. Raphael. He only points out the portions that he wants you to see. Let's talk about Salazar, if I may, Your Honor. Ms. Salazar testified as follows, which Mr. Raphael intentionally does not let the court know, even today.
Do you want to share screen it?
I'm trying to locate it, Judge, and then I'll share it with you. I don't want to waste the court's time having to look at my exhibits. Ms. Salazar we stand behind it, was our manager on the date of August 17th and 18th, 2017. We stand by that. My client stands by that. And if you look at her testimony, I am trying to find it, Judge. Now let me go. I think I should go to here's my response. These are the portions he leaves out. Exhibit 6, page 20, line 7 to 21. The question, so whenever a cashier was on staff, whenever a cashier was on duty, they were a manager in charge. So that's a shift manager that they are. Answer, The cashier, who did they report to directly? What's the answer? He only gives you half the answer in his motion. Doesn't give you the rest of it. It says, Griselda Ramirez or to me. So if the cashiers at the 2903 are reporting to her, what does that make her? In our position, she's the manager. And we read on. But the ones who reported to you, were they at 2903 or 2911? Both. Judge, he has sued El Paisano Northwest Highway, Inc., an entity. The entity has, let me show you this. This is his exhibit. This is the picture of the restaurant Northwest Highway, El Paisano Northwest Highway owns. There's two buildings, one with the white and one with the blue. There's a little tax office which prevented them from joining the two places together. That's the defendant. The two locations are the defendant. This is not one, that's not another one. When they testify, there are three different locations. They're not talking about these. There are three different entities. One, and I represent all three. One is El Paisano Northwest Highway, which is both of these. One is El Paisano South Carroll, Inc., which is another entity. And the other one is El Paisano Coit, which is another entity that's on Coit and I want to say Coit and Spring Valley. Those are the three entities, locations we're talking about. Now, if he doesn't know how to ask the right question, it should not be sanctionable on me. Three different entities, 4 different restaurants. These two restaurants are one entity, not two, one entity. And if I may go back to where I was, I'm sorry, I pushed the wrong button. That's why I don't like this remote stuff that we're doing. Let's go back here. No, wrong one. Sorry, Judge. Wrong one again. This is new to me. So let's go back and see what Ms. Salazar actually testified to in the entire deposition. Not just the portions that Mr. Raphael wants to point out to the court. So we go back here. So let's go back up here as we we're just talking about it. So she does admit that the cashiers on both locations, both buildings, report to her and says, the ones who reported to you, were they at 2903 or 2911? She says both. If both cashiers are reporting to her, what does that make her? In our opinion, it makes her the manager of El Paisano Northwest.
What is the role of Ms. Figueroa then?
I'll get to that in a second, Judge, if you allow me. And then she says, okay, what the cashiers report to you for? She says, if it's a small problem, they would communicate it to me. But if there was a large problem like the city, they would communicate it to Griselda, who is the owner. Let's go on some more. When I am asking questions, it says, when you wrote the paychecks and the bills, would you write them for both locations? Yes. This is the two on Lombardi. Out of the same account? Yes. So both of these locations, even though they may be divided by a tax office in between, they're actually one business. Would you agree with that? That's true. So even though they're physically separated by a couple of walls, is there actually one business there? Exactly. Then I ask him again. Then I think Mr. Rafael is asking this question. And here's the part about the documents. And again, trying to provide to the court the information as to who is the manager. If Ms. Figueroa is the manager, listen to this part, Judge. Mr. Rafael asked him, have you seen this document before that's titled Delta Security System Guards Agreement? Answer is, I saw it when Dora gave it to me. Why would Dora give it to Salazar if Salazar is nobody? Number two, yes. Why did she give it to you? Because Griselda gave the orders to contract security. Did she give that order to you or Dora? Griselda gave a general order for us to contact security, all of the shift managers. And again, who did she give that order to specifically? To all cashiers. So Figueroa was not the one who was given the task of hiring a security guard company. Let's continue, Judge. It says, next question. All right, there were a lot of questions asked of you about the security and the hiring the security. You were one of the people who was involved in trying to locate a security guard company when Griselda asked the managers to look for one, correct? Exactly. Next question. Who wrote the checks to Delta Security on behalf of El Paisano? I wrote the checks, not Figueroa. Now, here's the part that Mr. Rafael intentionally leaves out of his motion for sanctions, and I'll let the court decide why. I'm not the judge in this case. She was asked, was Dora working there when you left El Paisano? Now, remember, she left El Paisano April of 2018. Response is, had just come back. When did she come back? In 2018, but I don't remember what month. When did Dora leave El Paisano? 2017. When in 2017 did Dora leave? I do not remember. Now, let me just put my stuff in there because this is a personal attack on me. I want to make sure the record is clear. Then I asked, okay, now there was Daniela Ortega, and am I saying that name correctly? Yes, that's fine. I was told that we provided the information to opposing counsel that Daniela Ortega was the cashier for the night or the early morning where the incident between Mr. Martinez and Mr. Tovar occurred. Do you know if that's true or not? Or you don't know? I am not sure if it was Daniela Ortega or Ms. Figueroa. That's her response. Then I come back and say, there was an objection. So then I asked, let me rephrase my question. Do you know if on the night of the event that is the basis of this lawsuit, I believe it's August 17 or 18, you don't know if Daniela Ortega was the cashier or Ms. Figueroa, correct? That's correct. You said something that confused me a little bit. You said Ms. Figueroa had left and came back a little bit before you left. Do you remember that testimony? Did you say before? Yes. Question. So that would make it that Ms. Figueroa was not working in August of 2017 at El Paisano, would it not? I think that's correct. She was not working during that time. That's the portion he doesn't want you to see. That's the sham that's being played on this court. With respect to Ms. Figueroa, Your Honor, let me try to explain the situation. Ms. Salazar was the manager of El Paisano Northwest Highway, Inc., a legal entity that had two restaurants next door to each other with four walls separating it. She wrote all the checks. every manager reported to her. She was in charge of everything. That's why Mr. Guerrero had to give her the contract. Sometime in April of 2018, Ms. Salazar was caught creating fake employee lists because my client is in Florida, and as you saw here, Ms. Salazar writes the paycheck. So Ms. Salazar was putting these fake name employees into the payroll, alleging that John Smith was working there. And
Your Honor, this is not an evidence. That is going after her credibility. She testified very clearly that I have
May I finish?
19 pages of her testifying to that.
May I finish, Judge? He went far beyond what's in evidence also, so allow me to finish. I'm trying to explain to the court, I'm being sanctioned, and I can testify to this if the court allows me to. Ms. Salazar was creating fake employees using a stamp that was given to her by Ms. Ramirez to do the paychecks. So we cannot figure out who was working, who was not working. That's the problem. We have fake employees who are on the payroll. Now, the question that he asked was, who were the people working that night in his discovery? We gave the names and we stand behind those names. Now, if the court wants to, as Mr. Rafael wants the court, take Salazar's word and testimony as gospel, then yes, you're right, you should sanction me. But I think the testimony is subject to scrutiny by a jury. Ms. Salazar says some stuff, we say some stuff. Who's telling the truth? We don't decide that in sanctions.
Your Honor, we didn't receive any of those names until after all of those people were supposedly gone. We were in discovery for a year and a half, and they could have easily given us the names and their employees to interview.
I did not interrupt him. May I speak uninterrupted?
You can, but we're almost out of time. So
my point is, the entire basis of his motion is that he thinks Ms. Salazar told the truth and my client did not. He is not the decider of that fact. I think the trial of the fact will decide that. Now, we stand with our position, and I stated in my motion, we stand behind the fact that Ortega was the manager. The court ordered us to provide the W-2s and the 1099s and everything we did. We did, and our position is, and will remain, that when Ms. Salazar realized that she's being fired because she's being caught, she removed all the documents. She told you that they gave me the contract. So she took all the evidence that we could have used against her in a potential criminal case or a civil case with her. Now, if she failed to bring him, is that my fault or is that my client's fault? Of course not. So think about really what he's asking. Every time before a trial, he files a motion.
Go ahead.
Every time before a trial, he files a motion for sanction. Now, remember that Ms. Salazar was deposed in June. We're in November. We're set for trial December 1. Why did he not file that June 15, June 20th, July? Because the purpose of his motion is not to achieve anything, but rather shed the dark light on me or my client a week before trial. And this is really, really frustrating, Judge, because as much time as he spent, I spent. The court did rule on, which I have it here as exhibit number order, when he incorporated his first, second, and third motions in his third motion. He incorporated all of them. The court made the ruling, heard all the evidence, and the court said, Mr. Pema, do these or else. And every single thing you ordered me to do on March 6th, even though the order wasn't signed till July 13th. I need to share my screen. I'm sorry. Was I showing you that stuff, Judge, as I was talking to him?
You haven't shared the screen at all that I've seen.
My apologies, and I'm not going to waste the court's time going over them, but if the court wishes to see them, they're all in my response. What happened here? Can you see my screen, Your Honor?
Yeah, I can.
This is what the court ordered after his third motion, which incorporated his first and second motion. And every single one of these items that you ordered me to do, I did. Now, he keeps telling you about insurance. In his initial interrogatory request or production, he says, identify any insurance, and that's in his motion, that are relevant to this lawsuit, which means 2017. My response was, we do not have any insurance relative to that part. We did a diligent search, called everybody that we could. Now, keep in mind, Ms. Salazar is not talking to me. She's talking to me through her attorney. And we do not have insurance. I cannot prove that I don't have something. Now, think about it for a moment, Judge. If we had insurance, I wouldn't be here. There would be an insurance defense attorney handling this case and paying or not paying this matter. My client is paying me to represent it because there is no insurance. How can I provide something that I don't have?
But isn't there a company called Tapco that they had insurance with, and why haven't you provided that information?
We have provided that, Your Honor. We provided the policy, we provided the contact information, and then that's the email that he showed you. I have provided, your order was very broad, said from 2015 until present. The only policy that we have is the present, and I provided the policy as well as the name, address, contact information, the local agent, the whole shebang. And that's effective from date certain to date certain, which is 2019. Mr. Rafael does this every week before trial setting. Now, I gave him last time because he's right. There was a miscommunication, which I will address after at an appropriate time. But I agreed with this. This is the order that you signed. And if he can tell me how I violated this order, I would be more than happy to. I paid for the deposition, even though it was rescheduled. I paid for the translator. I provided all the W-2s, 1099s. Let's look at the order. It says provide the name, last known contact information. Are you seeing this? No, you're not again.
No.
It says, your order says as follows: provide names and last contact information for all staff, employees, managers, and contractors working at Paisano on the night of the incident on August 18th and August 19th, including Salazar. I complied and provided that. Produce the most payroll form for the persons mentioned above, the most recent. I provided that. Produce copies of the insurance policy from 2015 until present. There is none except the one that I provided. And then you also told me that I have to pay the cost of the deposition, which I did. So I'm being sanctioned, or my client's being sanctioned, because somehow Ms. Salazar's word is now gospel. Red light accident. Both defendants says I had the green light. Do we sanction one for lying just because I think my client's telling the truth? That's really what this boils down to, Your Honor.
Your Honor, if I may.
And we're running out of time.
I'll be very brief. Your Honor. Again, Ms. Salazar and Ms. Figueroa were never disclosed to us until we caught defendant not doing it. And I can show you again in brief. This is the contract with security company from the defendant that we had to go subpoena and fine from the security company, signed by Adora Figueroa, who was never disclosed. Furthermore, in Rule 609 disclosure, I am not going to take the word of Ms. Griselda Ramirez, who was sentenced to 14 months in prison for committing fraud. She committed tax fraud, Your Honor. And they're going to just say the credibility of Ms. Salazar is not, she's not credible. Well, Ms. Salazar was never disclosed to us for 3 years until we caught her because the defendant was suing her. Now they're going to blame her for everything. And last point, in her deposition, Your Honor, she states unequivocally multiple times, and it was a translated deposition, if I may add. Which location was that? 2903 Lombardi. You were not the manager of 2911. That's correct. Do you know 27 who was the, no, 2911. Over and over again. And as Mr. Pema testified almost in the corporate rep deposition, there are 4 separate entities, 2 different restaurants. And we were told that whenever, even in our last hearing, I asked, 2 separate entities insurance, he says they have multiple entities, they can't keep track of everything. They cannot blame Ms. Salazar because every one of these missing employees worked at El Paisanos for over a year of discovery and could have easily been disclosed, and they never were until the middle of July 2019 and then March of 2020. And we were never given contact information, only addresses and saying, go find them.
Your Honor, if Mr. Rafael does not know how to draft a proper interrogatory request, that's his problem, not sanctionable on me. He asked, provide me with the insurance that's relevant to this lawsuit. I said, we don't have any. He says, give me the name of the employees that are working on the evening that this incident happened. Ms. Salazar was not working that evening. Why would I provide her name if she was not? It was pursuant to your order that says provide Salazar's name. It was
These are disclosures, Your Honor. These are simple disclosures. You have to provide the names and contact information of witnesses. And this was during discovery, 1.5 years of discovery. These people all worked there.
Your Honor,
and I can pull up every interrogatory if you'd like.
Your Honor, he's misleading you. The disclosure says people with knowledge of relevant fact. He asked Ms. Salazar, do you have any knowledge of the incident? She said no.
She was never disclosed, Your Honor.
Huh?
She was never disclosed, nor was Dora Figueroa until we found them lying to us about it. And Dora Figueroa has still not been disclosed.
Your Honor, listen to what he's saying for a moment. He says in my requested disclosure, which says identify people with knowledge of relevant fact, you fail to disclose people who do not have knowledge of relevant fact. How is that sanctionable? I could have named my neighbor for all that matters. His request was people with knowledge of relevant facts. Salazar was a day manager. Figueroa was gone. How would that be relevant? How is that compellable? How is that sanctionable? It was not until you gave the order for me to provide that information, which I did, and he deposed her. How can I?
Because you never provided Figueroa.
Because Figueroa never worked there during the time. The question was people with knowledge of relevant fact, Your Honor. Why would I disclose 1,000 names who've worked from 2015 that had nothing to do with this? Now, he read that portion to you, but I also showed you, I believe I showed you, and I apologize, Judge, but Ms. Salazar retracted what she said. I got to find it first. Ms. Salazar retracted her testimony when I asked her about, and I'll share it this time real quick, Judge, so that you see it. He doesn't want you to see that. But when I asked her,
I could share it. I have it on my screen.
I got it. When I asked her,
Mr. Payman, either if you're not going to share the screen, you're going to have to let Mr. Ori share the screen. So you keep saying you're going to share it, and you don't share it.
Is it shared, Your Honor?
Yes. What?
All right. So this is what I was talking about. My clients do have 3 locations. El Paisano, South Carroll, which is about a mile or 2 down the street. El Paisano, Carroll, which is down North Dallas. El Paisano, North Side, which is these 2 restaurants. So when I asked her, so those 2 locations, even though they may be divided by the tax office in between, they're actually one business. Would you agree with that? That's true. I asked her. When he asked about seeing the contract, he says, have you seen this document before, that titled Delta Security Solution Guard Service Agreement? I saw it when Dora gave it to me. This is back in 2016, a year and 2 months before the incident. And then why did she give it to you? And she says, because Griselda told us to do this.
Griselda, who testified, it was all Ms. Salazar.
Your Honor, Ms. Salazar says higher security to all the managers. The testimony is there. You just need to read the testimony.
Okay, let me ask a question here. So what are your defenses in this case, Mr. Payman?
Our defense is, first of all, that the assault never happened. Mr. Tovar will testify that the evidence that we have, Judge, is Miss.
I just need to know the defenses. I don't want you to, I don't need closing arguments. I just need to know the defenses.
I have asserted that she started the fight. She hit on the security personnel, security defense, took her outside. She may have something happened to her. She was highly intoxicated, as testified, and it's in my motion by the. I
don't need it. I just need to know what your defenses are.
My defenses are they never happened. We didn't touch her. Security guard took her out.
That's you don't have any defenses because they've argued negligent hiring. Is that correct?
Well, you allowed us. We hired Delta Security, and you allowed us. He brought him in a day before trial. Last time he dismissed them, but you allowed me to designate him as responsible third party because the hiring was done by Delta. We hired Delta Security, which is a legitimate company, and Mr. Raphael sued them. And a week before, they never filed an answer. A week before trial or 2 days before trial, he dismissed them. Based on that, the court allowed me to designate him as responsible third party. On the negligent hiring, that's our defense.
What I'm trying to get at is I do think there needs to be sanctions. I don't think they need to be death penalty. They need to be tailored to the discovery abuse. And that's why I'm trying to figure out what the defenses are and possibly strike defenses related to this discovery abuse. Like, this discovery abuse really has nothing to do with the injuries. It really has nothing to do with how the actual the incident happened. It has to do with issues involving how the hiring occurred. And so what my thought is something along the lines that the jury be instructed that the court has found as a matter of law that the defendant was negligent in hiring the security company because you've done everything possible, I feel like, to try to obscure how this exactly happened. I'm not blaming you, Mr. Payne. I think it may be your client. You have a client that doesn't seem to be terribly forthright.
Your Honor.
Your Honor, I may add, the event happened. What's important is the manager who told the guard to take her out. That is what's important. The guard was told by the manager to take her out. And we don't know who that manager is, and that is what's vital, because Mr. Tovar was an unlicensed security guard. Delta was no longer working for them.
Now
we provided all the checks signed directly to Mr. Tovar. That's in evidence. Defendants gave us those checks, all to Mr. Tovar, who was an independent or an employee, we could argue at the time, but all the checks were directly written to him as an individual. And the manager who told him to take my client out, that is what was vital. And that's what's been missing the entire time until recently.
Your Honor, he's misleading you again. The security guard company was hired in 2016, a year and 4 months before this incident. Their own expert put the blame on the security guard company.
If I may, Your Honor, I could show you the checks from defendants to Frank Tovar individually at the time of the incident. And he worked there for a full year afterwards, a full year after the incident. And they still say, oh, we don't know how to find him, can't find him, anything. It has been entire just wall after wall after wall, like it's a criminal case that hiding evidence. It's a simple matter. Somebody told the guard, take her out. And we don't know, we couldn't get a hold of this guard who worked there for over a year. We couldn't find the employees for over 2 years. And they still, at 3 years, actually, the people who are really responsible, because it was a nighttime manager. And they blamed Ms. Salazar until we found out they were suing her. Mr. Pema and defendants were suing her. I think we lost her.
Okay. So I guess I've tried to be as clear as possible. I want to tailor this sanction to the discovery abuse. I think if I did a complete death penalty sanctions, that would be overturned, and it should be overturned. I think it's too broad. I do think that they've obscured your ability to find out certain information that is important to the case, but does not go to the issue of, exactly how did the accident happen? Was your client drinking? Was she not drinking? How responsible was she? What her injuries were? None of the discovery abuse goes to those issues. It only goes to the issues of the relationship between the security company and the
well, then if I may offer, Your Honor, how about striking the fact that any defense that the guard was an independent contractor, instead saying that he was an employee?
Or striking the third party designation?
Yes, Your Honor, just directly saying that he was an employee, because we have it all in evidence that he was paid directly by them. Yeah, because
guys, because this was only set for 30 minutes, so we're way over time. So what I'm going to do is I'm going to allow you each to do a 2-page brief and attach your own order. I want an order that's narrowly tailored to the issues, whether it's striking the third-party designation, whether it's doing a ruling that. Okay, Mr. Payman got knocked off. Okay, well, go ahead and tell Mr. Payman. I don't know where he went or kind of what happened. So just tell him that each side is going to have an opportunity to do it. And this is on YouTube, so he can look it up. I don't know where he's gone or what's happened. So 2-page brief. Each of you guys provide proposed orders. I am going to issue some type of sanction. So Mr. Payman is going to need to come up with, how to tailor it. You need to come up with how to tailor it. But it needs to be focused on the discovery abuse at hand. All right. Thank you so much. And
thank you, Your Honor.
Next one, Zubar versus Gonzalez, cause number DC 1918220. Counsel, make your appearance.
I was waiting for the plaintiff. Good morning, Your Honor. My name is Greg Fell. I represent Francisco and Marianne Gonzalez.
Your Honor, Braulio Gonzalez for David Smelser, the Smelser parties, the Sorensen parties, and the first amended Phillips Trust.
Casey Myers on behalf of Valley View Park Estates.
Mr. Miller, are you going to make an announcement? You need to unmute, sir.
Brett Biasy on behalf of the Valley View Park Estates.
Yeah, Robert Miller on behalf of Charles Zubar, Your Honor.
Okay. So I made a ruling on this. I guess there's a question about when the ruling should go into effect, is my understanding. So let's kind of hear argument on that issue.
Yeah, thank you, Your Honor. Your Honor, we're seeking some clarification to avoid a possible contempt issue. It's all the defendants' position. This was a joint motion that because the summary judgment order did not dispose of all the claims and all the parties, it is interlocutory, therefore not subject to appeal, depriving any of the defendants from appealing it. So I've cited a couple cases that came from a case out of San Antonio that's right on point. And if I could just read a couple blurbs from that, I think it would be helpful. It's not a reported case. It's 2014 Westlaw 668-7242. It's a case styled El Caballero Ranch versus Grace River Ranch. And in that case, the issue was an easement, just as we're dealing with here. And the court, in a partial summary judgment ruling, exactly like what has occurred here, granted use of the easement. And in other words, the ultimate relief, what in essence was a permanent injunction. And the court, in a memorandum opinion that was turned into an unpublished opinion, stated that, concluded that the trial court abused its discretion by allowing the use of the easement prior to the final determination of all the parties' claims and entry of a final and appealable judgment. And they granted the mandamus relief and directed the trial court to vacate that portion of the judgment that granted the immediate use of the easement, much like we have here. And in that case, the parties did exactly what we're doing here. They approached the court after a motion for contempt was filed. And in this case, we're approaching the court before that happens, trying to get some clarification so that we don't run afoul of the court's ruling.
Not unreasonable response.
Yes, Your Honor. I cite a case out of Fort Worth that is published, the L Series LLC versus Holt case, which is unusual because it's similar to our case, because the court found on summary judgment that the L Series LLC had to pay Holt his attorney's fees as the case went forward. They didn't have to wait until the end. The court said you have to pay his attorney's fees because that's what your contract says. They had a contract with the LLC and the operating thing that said that they would pay the attorney's fees if somebody got sued like this. And that's very similar to our case, where we have a contract, a declaration that says you won't put fences or structures in the easement area. They went ahead and they breached it. We get our attorney's fees for that. We also get the decision by the court that you got to remove them, because that's the only thing that you can do. So I think my case, although it's in Fort Worth and it's very long and talks about Delaware law, is more on point than their case. And that you can, it's too bad that they can't appeal, but that's the way things are. And, there will be a final judgment in this case when they.
So what is still left in the case? I guess I've ruled on that issue. What is still left?
My attorney's fees, Your Honor. And it's set for hearing on December 11th. And once that is done, you'll have a final judgment that can be appealed. Now, if the court goes ahead and says, no, you got to remove your fences now, and for some odd reason, the Court of Appeals decides that was wrong, we would have to reimburse the other side for their cost in removing the fence, I guess. But
the only issue left is the issue of attorney's fees?
No, Your Honor.
That's not accurate, Your Honor.
That's not accurate.
I don't know what else.
Mr. Gonzalez, what else is left?
Your Honor, there's third-party claims from defendants against the HOA. There's a cross-claim on file, the HOA against Mr. Zubar. And if I may, jumping back into Mr. Miller's argument, his case is on point for the attorney's fees that he's seeking December 11th, but the easement issue is straight on point on Mr. Fell's motion with the cases he cited.
Would it be possible? My initial thought when I read this was that the way I usually deal with things like this, not exactly like this, would be to sever it, to make it, because I agree the defendant should have a right to appeal me. I don't really want to order them to tear this down and then somehow impair their rights to appeal. And so I'm asking them to take some type of affirmative efforts in this case. Would it be possible to sever this, make it the judgment as to the removing the fences and the other things I've ruled on final, and then continue on with the rest of the case? Is that a possibility, Mr. Miller?
Well, the problem is, Your Honor, that all the other cases that are percolating all sort of have been decided by you because they say they have the right to do this and that, and they don't. So you can sever the case, but there's the judgment's still out there. And what they propose in their stuff is that Mr. Zubar didn't follow the declaration because he had to go to the board of directors first, which he did,
Correct. Yes, that is correct.
But that's already been decided because the judge, that argument was made in the summary judgment hearing and it was overturned. It was not, he granted the summary judgment. So I think that's already been decided.
Okay. I mean, I guess you're talking about what exactly have I decided, not whether or not it's a good idea to sever.
Your Honor, in the summary judgment, you pretty much decided that the fences were a violation of the declaration. Right. That's pretty straightforward. However, there's outstanding issues to whether Mr. Zubar violated the declaration as well by not following the prescribed procedure that he needed to in order to bring his claim. He did not follow that. As well as there's issues where whether we, the defendants individually, were the correct party or with the HOA the correct party, because the HOA had granted permission to put up the fences. Therefore, we as defendants brought in the HOA, and the HOA brought a cross claim against Mr. Zubar for failing to follow the declaration. Which
it was all content. That depends on whether you consider what he did was a dispute between two members of the association, or whether this is a member of the association enforcing the declaration, which was just torn to shreds by this board of directors. They violated their fiduciary duty. So I think that the issue's already been decided, Your Honor.
Okay, that's not really what I'm getting at. So what I'm going to do is I'm going to sever out everything that I've decided in the summary judgment. So that entire judgment is going to be severed out into a separate cause number. I wanted that to be a final judgment, and then whatever is left, and we can, I guess, debate that. Whatever is left, whether or not it would, you could argue, I guess, in the other case, or the old case, which would be these cross claims and stuff like that, whether or not they've already been ruled on, you can bring summary judgments as to those. But I want to finalize this issue involving removing the fences so that the defendants have a right to appeal that. So go ahead and get me a judgment on that.
Judge, if I may, there is currently a motion to sever that is on file, that is pending. Responses have been filed. Is this going to be a ruling on that motion without hearing any argument?
I'm sorry, I didn't know that. And so is that what it says? Is that what you're trying to do?
Well, Judge, it sounds like what Mr. Miller has advocated here is actually for his motion to sever, which is not set. It's been filed, responses have been filed, and it seems kind of a backdoor argument here now to a motion.
I'm not sure I fully understand that, but what is the status of the motion? So someone already, who filed the motion to sever?
Mr.
I
Miller
did.
did.
And it was set for hearing on the same day as the summary judgment hearing. We didn't reach it.
Yes, Judge.
Yeah.
You
So it was
said that
already
we could argue
set, so I'm going
that
to go ahead and
motion
rule
at
on
another
that
time.
I'm sorry?
You said that we could argue the motion to sever at another time because we had taken up so much of the court's time for the
So
summary
I'm going to
judgment.
go ahead and rule on it today. I'm going to go ahead and grant the motion to sever then. And sever out any decisions I've already made regarding the fences and to give you guys a chance to appeal them. All right, anything else, guys?
Thank you, Judge.
No, Your Honor.
Your Honor,
Mr. Miller, just get me in order, okay?
well, my question is, when you sever this out, how long do they have to remove the fence? Is it,
They would have to do it immediately unless they get appeal it, because that's when the judgment becomes final. At that point, they could appeal it and either do a supersedious or whatever to stop that from happening if they want to appeal it. Otherwise, it would need to be immediate.
Well, Judge, let me chime in if I may. If I understood you correctly, what you're saying is you're going to sign
Megan,
I'm sorry?
go ahead.
You're going to sign an order severing what you've ruled upon, and I understand that. And is it your opinion that that would immediately become a final order rather than becoming a final order within 30 days after severing?
It would become a final judgment and you would have the rights to appeal just like any other final judgment. All right, guys, thank you so much.
Judge, can I just say one more thing, please?
Sure.
Judgments become final 30 days after signing. And
I'm not changing any of that. It's just, I'm going to sign it as a final judgment and then you have the right to pursue it however you want to pursue it. So I'm signing it as a final judgment and just like any other judgment, I've signed thousands and thousands of judgments. It'll be just like any other judgment. Changing the rules for this.
One of the things that we asked for in our motion was a modification of the judgment so that it reads enforceable 30 days after becoming final. As you wrote it, it becomes enforceable in 2 days. So what we're asking the court to do is simply to modify it so that it says remove the fences within 30 days upon the judgment becoming final. And I think that would solve a lot of issues.
Your Honor, I have a question about the final judgment and my attorney's fees. That's set for hearing on December 11th. And that's one issue that's not been decided in the case.
Your Honor, that's the problem with severing it. That every other claim still alive involves this main issue.
All right, guys, I appreciate all your questions. I've made my ruling. If you guys can go ahead and get me an order on my ruling and we'll go from there. Okay, guys? Thank you so much. Do you guys have any, but I do need to get to my next hearing, okay?
All right.
All right, guys, thank you so much. Sorry.
Thank you,
Thank
Judge.
you.
Thank you, Your Honor.
Okay, is anyone here on 1927 Beltline versus Dallas Central Appraisal District?
Yes, good morning, Your Honor. Darlene Sullivan here for plaintiff 1927 Beltline et al. And
Anyone here for the defendant?
I'm not sure. I was looking to see if anybody was without the camera, but I don't see them on here.
Okay, this case is set for trial, I believe, on December 30th. Is that correct?
It's December 15th.
December 15th, okay. And what's the issue? Why do you guys need a continuance?
So we have filed an agreed motion for continuance. This is our first trial setting. And the property involved, it's 40 different individual properties. And we have reached an agreement on the majority of them. And then there's 2 out of those 40 plus properties that had some additional issues that we're hoping to be able to resolve, because really the majority of the case has been worked out and we're just waiting on those 2. Just given the fact that everybody's remote and we do have some personnel from the appraisal district out, we just needed a little bit more time to make sure that we can wrap up those last 2 and finalize the suit.
My concern, I guess, is that, we haven't had jury trials until this week. We actually did a jury trial this week. And so I'm trying to get as many non-jury cases resolved as possible while we're kind of in this hiatus. How much time would you need?
I think for us, even a 90-day continuance would be sufficient. Unfortunately, one of the properties sits primarily in Denton County, and so Denton just has to set the value on that, and then Dallas will typically be agreeable to that. So on our end, I think 90 days would be sufficient.
Okay, I will set you for trial on March 16th. All right, anything else?
Nope, that's everything. Thank you very much, Your Honor.
Thank you. Just let Mr. Hicks know, okay?
I will.
Thank you. Perfect, okay. DC 2000690, Nichols v. Progressive Insurance Company. I've already signed that order. I don't think I had, but I did sign the order. So I don't know that there's anything else to do on this case.
Your Honor, Zakima Henderson for Progressive. If you sign the order, then that resolves the issues that are set forth in the motion.
Do you want to just check the docket? That was my fault. I guess I didn't see it or wasn't given to me or something. And so if you want to just double check that that's the order, let me see if I can pull it up. I just want to make sure this is the order you were asking about.
Then the other thing, Your Honor, is we are set for trial on December 15th. And so with that order being entered, originally you ordered Mr. Nichols to produce documents by August 10th. And so we would ask that you order him today to produce those documents, perhaps in the next few days, so that we can certainly have time to review them and issues before trial.
Let me see real quick. Let's see. I'm going to go ahead and share a screen and you just tell me if this is the document you were asking about. Is that the order that you were asking about?
It is, Your Honor.
Let me just make sure it's signed. So, and you said we have a trial setting, is that right?
Yes, Your Honor, on December 15th.
Did you want to, is it a jury or non-jury?
Right now, I believe it's set for a non-jury trial.
Let me just double check. Oops. Okay, and so I apologize, maybe, did you say you wanted to try to continue it, or did you say that you wanted the documents more quickly?
We wanted the documents more quickly.
All right, Mr. Nichols, has he not given you the documents already?
That's correct, he has not.
Okay, Mr. Nichols, are you there? Okay, so I'm not sure what's going on with the sound. Let's go ahead and just, do I need to do a supplemental order just saying he needs to get you the documents within 7 days?
Yes, Your Honor. And the other issue is you had ordered that he was supposed to mail those, and you declined his request that Progressive would have to pay for the cost of mailing. And so I'd like to be able to include that in the supplemental order so that that's not an issue again.
Okay. Yeah, go ahead and just do a supplemental order and say that.
Excuse me, Your Honor.
Okay, Mr.
Excuse me, Your Honor.
Yeah.
I just wanted to state in response to Attorney Henderson's request for the documents, I made several good faith efforts to get those documents to her. In dispute, when you and I talked about the task queen, you asked me how much she charged. I said it was about 10 to 15 cents per page. And so once we left the court and you ordered her to write the document, she stated that it was only supposed to be for 10 cents per page, which was created a barrier between me getting the documents to her and resolving the amount with the task queen, as well as you told me to go to Office Depot and to have them to send it to her. So I would not have never been involved. My only thing was to have had the documents taken so that they would be sent to her, and that information was supposed to be negotiated with that individual. But Attorney Henderson made this a matter of name, blame, shame, claim game in order to try to cover up the frivolous motion to compel when I've already made good faith efforts, even from the motion to compel, to go to Office Depot initially and had issues with her.
Response. Ms. Henderson, we can't hear you. We still can't hear you. We still can't hear you, Ms. Henderson. Can you guys hear me okay?
I can hear you, Your Honor.
Okay. Ms. Henderson, can you hear Ms. Anderson? No, okay. Ms. Henderson, it seems like
Can you
you're
still
having.
not hear?
Okay.
Can you hear me now?
Yeah.
Okay. All of the issues that he's addressing right now are issues that had come up prior to the motion to compel, and that hearing resolved all of those issues. Since the motion to compel, the only issue we've had is that he refuses to acknowledge that you set the limit at 10 cents per page. I don't know whether or not he brought up it was 10 cents to 15 cents, but your ruling was that the limit was 10 cents per page. And that's within the order that you've now signed and resolved the issue. He did amend his discovery responses pursuant to that order, but he has still refused to actually produce documents. And there haven't been any communications between us about him making good faith efforts or not. He just hasn't produced them.
Okay, go ahead and get me a supplemental order that these documents need to be provided within 7 days. And you said there was something else you wanted to add to the order. I forget the.
Well, that the Progressive is not responsible for covering the cost of him mailing those to us.
Right. That's standard. Okay, guys, thank you so much. Just get me that order, Mr. Nichols. Go ahead and get the documents over there, and we'll see you on December 15th for trial.
Thanks, Your Honor.
Dave.
Have a great one.
You too. Versailles, Dallas versus Atun. Are you guys there?
Good morning, Your Honor.
Yes, Your Honor. Good morning.
So let me just ask this before we get started. Is this motion agreed to or not? I couldn't tell.
No, this is opposed, Your Honor, and we filed an opposition. There's actually two motions on. There's a motion for continuance. They're asking for continuance until June of next year at a minimum. And then they have a motion requesting an untimely motion requesting a jury trial that Ms. Pettit's clients have twice waived. And in addition, there's another motion that was filed by Mr. Suster claiming that Your Honor created a disqualifying conflict of interest 34 days ago or 35 days ago when we had the hearing on the motion to compel on the 1,896 discovery demands, but he hasn't set that for a hearing yet, according to what the docket is showing.
And so, in the hearing, the trial is set for when?
It's December 8th, Your Honor, non-jury trial, and that was an agreed setting at our September 22nd trial setting, at which time Mr. Suster went on the record and indicated, and both parties did this, it was our jury demand. We withdrew our demand, and all parties agreed to proceed non-jury with a live trial before the court.
Yeah, Ms. Pettit, you're jumping in the middle of a very, very deep hole that's been dug for you. I don't usually grant continuances because of late changes in attorneys, and I don't think it would be fair to Mr. Scott to do that here. And but of course, I'll be glad to hear what you have to say.
Thank you, Your Honor. If I may respond and address what's in our motion. So I don't think there's any doubt that at the last hearing, it sounds like my predecessor counsel did on the record waive a jury trial. We've attached affidavits to our motion, including an affidavit from prior counsel that he had absolutely zero client authority to do that. The clients have signed an affidavit, both clients have attached it to this motion as well. So the clients are swearing under oath they never gave this lawyer authority to do it. The lawyer himself is swearing he did not have client authority to do that. This case had been set for jury trial from the beginning. The jury fee had actually already been paid by the other side. All of their pleadings in this case by the defendants had consistently requested and demanded a jury. And so there was never any doubt from my client's perspective that there would indeed be a jury trial in this case. And I understand that this did happen, and it did happen on the record. However, I would ask that my clients not be prejudiced that their former counsel agreed to something that they've never authorized him to agree to. And so for that reason, we have requested this to be set for a jury trial, and we've also requested a continuance. Mr. Hurst will also be making an appearance on this case. He's in a injunction hearing today in Judge Parker's court, so he wasn't able to be here this morning. So I understand this case has been going on. There's certainly been a lot of issues, some of which I've read about, some of which I'm sure I'm going to read in the near future. But I would ask that my client not be prejudiced based on this action of prior counsel. And I can assure you that new counsel is coming in. We will be very reasonable and follow Your Honor's orders and make sure that there are not the types of issues that perhaps this case has experienced prior to today.
I don't necessarily have a problem moving this if Mr. Scott agrees. I don't think it's fair to Mr. Scott and his client we have to be able to accept if an attorney makes a representation on the record, I have to be able to assume that that's something they had authority to do. Mr. Suster is a very experienced counsel. This isn't a first-year lawyer that, got nervous in front of a judge. He knew what he was doing. I didn't fully get why some of the decisions were made the way they were by your predecessor counsel, but that's not for me to really judge. But if Mr. Scott wants to move it, I'm happy to move it. If he doesn't want to, then I think we need to keep it where it is. Mr. Scott, what are your
Your Honor, we have to strenuously oppose this. There has been, and it's no knock on Ms. Pettit, new counsel, but there's been a long and protracted history in this case of delay after delay after delay, including mandamus proceedings on discovery orders. And when the Court of Appeals ruled against them and your order went back into effect, they still haven't complied with your two discovery orders. So you have a long history of disregard for the rule of law by the El Chamis and by Versailles. And there's another point, Your Honor, the counsel may not be aware of, if I might share the screen with you. I indicated that they waived a jury and that they had not requested a jury, but they also contractually waived a jury before this case started.
I'm aware of it.
Excuse me? I'm sorry.
I just wanted to let you know, I've seen it.
You've seen the contractual waiver. I'd like to show it to the court. Your Honor, may I share the screen?
I mean, I'm already ruling in your favor. I just don't have a lot of time. So
I understand.
you can't do any better than what you've just done. So, but if you want to, she agrees, I agree. He made the representation. Ms. Pettit, I admire that you're willing to jump into a situation where you're, there's been kind of a deep hole dug, but it doesn't just go away.
Sure. Only other thing I would, I guess, add is typically I don't ever make any requests regarding personal issues. I am getting married 3 days before that, and I'm supposed to be on a honeymoon on the 8th, but I have told my fiance that part of my job means sometimes we don't get to do things we want to do. So
no, I don't. That's a good. I do want to try to accommodate that. I would highly, and I do accommodate that kind of stuff all the time. When is your honeymoon over?
that weekend, which is my calendar in front of me, but give me 1 second. We'll be back. I'm sorry. The 15th, Your Honor.
The 15th, you said you get back. What I would recommend is maybe we reset the. See, the problem is right now. I mean, I'd be happy to try this on January 7th. If you guys want to, my next jury trial, we're going to try to do another jury trial in late January or early February. So January 7th, I'm pretty open, but I wouldn't want that to reopen. Usually you have to do 30 days. You have to request a jury 30. I guess you already requested a jury, but then waived it. You waived it before, your client waived it before, and then they waived it again. I don't want this extension for your honeymoon to somehow reopen. I don't want you to make a new demand. Does that make sense for a jury?
Yeah, if Your Honor is denying the request for, or the motion for a jury trial, I will not renew that request based on the trial being continued.
Mr. Scott, I would highly recommend that we moved it to January 7th. Does that work for you?
Your Honor, I can do January 7th. I just want to make sure the record reflects that what counsel is saying is that we're trying this case non-jury. And I would ask that January 7th date be marked as a final date, no continuances by either side. Because we have, Your Honor, about 8 or 10 witnesses that have been subpoenaed and 3 experts whose calendars we've cleared in order to make them available for this December 8th trial. So this creates all kinds of work. I'm not trying to in any way, congratulations to counsel on her personal event. I appreciate that. I just want to also mention, Judge, Mr. Suster and Mr. Smith are not predecessor counsel. They are still lawyers of record in this case. They have not been granted leave to withdraw. We're going to oppose that. They have not shown good cause. They haven't even put it on for hearing. So they're still the lawyers in this case, in addition to Ms. Pettit and her firm. So Ms. Pettit appeared as new counsel, and there's a motion pending with no hearing set by Mr. Suster's firm claiming that you created a conflict because you threatened him, is what his motion says, and therefore it was necessary for the clients to change counsel.
Obviously, I strongly disagree that I threatened him. They filed 1,600 discovery requests, and I told them I wanted him to confer.
Yes,
he refused to confer, and then I said, "Look, if you want to stand on every one of these objections, you can, but if you don't, then I'm gonna sanction you." And that was not a threat. It was, "Hey, you need to confer," and he refused to confer. I was really, anyway, I'm not going to get into that again, but.
So my request, Your Honor, is if we are to continue this for January 7th, it would be on condition that it is a non-jury trial and that it's final.
So let me make sure I understand kind of where we are, because I didn't really think about that issue. Who is lead counsel on this case now?
Well, Your Honor, lead counsel before Ms. Pettit came in
May I
was
respond?
Israel Suster.
Let Ms. Pettit.
Sure, I'm
May I
sorry.
respond? Your Honor, I filed a notice of appearance as soon as I was hired so that I could begin to address the issues in the case. And then I filed a notice of designation of lead counsel as well. There is no question, there has been no question, I'm lead counsel in this case. Mr. Suster has filed a motion to withdraw. I can't speak for him on what he files or why he files it. I'll, of course, let him know it needs to be set for hearing, but there's no question I'm lead counsel in this case and will be.
Did we ever work out the issue of all of these discovery requests they sent? I don't remember how that was resolved.
Your Honor, my understanding is there was nothing ever worked out. Unfortunately, my client, based on what happened, I understand before I was here, there aren't forthcoming responses. So my client is going to go to trial without the benefit of any discovery responses at all or any depositions in this case. I understand that's the reality and we'll be prepared and put our best case forward. I also do want to let you know we have filed a motion for a new trial. We filed it 2 days on the severed granting of the summary judgment against all of my client's claims. It hasn't been, we filed it 2 days ago. It hasn't been accepted yet, but we do plan to set that for hearing once it has been accepted. So I just want to make sure Your Honor is aware that at least that that is on file. Understand that.
You know,
well, I'll keep it.
I'm a little concerned about that because if we didn't move the, I don't want you to be able to benefit from us. I think you've heard me use this term before. I want to kind of put the case in amber, which means that it needs to be frozen from the point when it was set, which is December 8th, I guess, to January 7th, that you shouldn't be able to get an advantage because of this, because of and I want you to be able to go on the honeymoon. That's not the issue, but I don't want it to be able to work to the detriment of Mr. Scott. It's already going to be a detriment because, you know, the trial is set. Remind me, Ms. Pettit, when is your wedding set again?
The 5th.
The 5th?
Yeah, that's a Saturday. The trial setting in this was on the 8th.
Okay.
When my office spoke with your coordinator, I believe yesterday, like I said, the motion for new trial hadn't been accepted, but they had already told us that it was unlikely there would be any hearing available prior to the trial date and that it would likely be set, if at all, on the date of trial. So I understand that. And if Your Honor doesn't wish to have a hearing on the motion for new trial and deny it without hearing, I believe Your Honor has that right as well.
And Your Honor, this is part of the problem in the case, which is there's a pattern here on the part of the El Chamis in Versailles. When they bring in new counsel, they want to start over and relitigate all the motions. And we've had this over and over again. This is exactly what Mr. Suster did. We litigated discovery motions, motions to compel. Arguments were either omitted or not made, and counsel that was of record at the time, Mr. Ertl, made the arguments. We had a hearing. Your Honor made a ruling. Then they came back and filed an emergency motion for reconsideration, essentially arguing all sorts of things that were unpreserved and never raised before. Then they went to the Court of Appeals with a 90-page brief in which, or 80-something page brief, in which 78 pages of the arguments were arguments that they never raised. And this motion for new trial is raising new arguments that, if at all, could have or should have been raised before. So it's not really a motion for new trial. It's a second bite at the apple. And we have this over and over again, and it's costing us a huge amount of time. It's delaying us. And I'll remind Your Honor, when we argued the motion for summary judgments, this dealt with the release that Versailles and the El Chamis signed with Prosperity Bank. And you had indicated when we had the hearing to adversary counsel, Mr. Smith, that you had reviewed the filing. And this was, as far as you were concerned, this was the strongest case of a dispositive release that you had seen, and invited him to make all of his arguments to persuade you that there was something here. And he had nothing in order to convince the court. And I don't want to get into arguing this motion that hasn't been set yet, but I am concerned that this delay will result in more filings, more hearings, and then an indication that there's not enough time for Your Honor to consider this and for
So
briefing.
this is what I fully respect that, and I'm just as concerned as you are about that, although I have a great deal of faith that Ms. Pettit she knows how this court operates. She's been in this court many times, and she knows kind of what the boundaries are here. I'm not going to allow any additional filings from the date, so from December, whatever it was, the date of the trial setting. And I realize that I told you the wrong date. It's not January 5th. January 5th. There's not going to be any additional filings, any motions filed during that time period. So any motions you need to get filed need to be before whatever the trial setting is, this current trial setting. I agree. I don't want to reopen things. I don't want new discovery. This case was, I'm going to accommodate, but I'm not going to give an advantage because of this. So can you include that in the order, Ms. Pettit?
Yes, Your Honor, just so I'm clear, there will be no new motions or filings from the current set trial date of December 8th, moving forward.
To the January 5th. No filings, no new discovery. The case is set in amber.
Your Honor, I would request that with regard to new motions or filings that we set it in amber as of today, because they're already getting an advantage by having this time to make a bunch more motions or filings. I would ask that the court, they file their motion for new trial. It's going to be docketed probably today or tomorrow. We will file a response and the court will rule on it or not rule on it as Your Honor feels appropriate. But to avoid prejudice to my clients, that should be it.
Let me make another clarification because I understand where you're going with this. Also, nothing can be set during that time period. So if they file it now, it can't be set during that time period either.
Yes, Your Honor.
Does that address your issue?
Well, only that between today and January 5th, that there's no new request for affirmative relief by either party, no new motions, we already covered the jury demand, no new discovery demands, nothing that's going to require us to then engage the court on yet another dispute that could derail the trial.
Nothing will be filed, set, discovery won't occur, nothing will occur from the date of the current trial setting to the date of the reset trial setting. That's going to be my ruling. So go ahead and put that into the order, Ms. Pettit. Guys, I need to take a quick break. We've been kind of going nonstop and I have to swear someone in. So I will be right back. Can you get me that order, Ms. Pettit?
Yes, Your Honor. Maybe we'll be excused.
You may. You guys have a good day.
Thanks, you too.
Jay, do you have a proposed scheduling order? You're on mute. Okay, I think we need to mute again because the judge is back. Sorry.
Now the judge is going to swear someone in. You're on mute, Bob.
Mr. Clark, you're muted.
Yes.
You, No, I
Let me
don't
give
have.
you my cell phone, 214-460-4231. If you could call me and then let's talk offline while he's swearing that person in.
Christina, did you get that scheduling order I sent over to you?
Yeah, I did. So I'll talk to Barrett about it after this hearing.
So is everyone here on West Summit Investments?
Judge Carson Runge, I am not. I'm here on Himmel versus Griffin.
Your Honor, this is Howard Mark Spector. I'm here on West Summit.
And this is Paul Hoffman. I'm here too.
Okay, you need to turn your video on. Let's go ahead and go on the record on cause number DC 1712500, West Summit Investment versus Neil Richards Group. Counsel, make your appearance.
Your Honor, this is Howard Mark Spector. I'm the receiver.
And I'm Paul Hoffman for Glendon Todd Capital and Hefe Plover Interests.
Right, let's go ahead and proceed.
Your Honor, last month you approved the report on the NRG Dallas receivership entity. About the day that the order was entered, I was contacted by one of the limited partners who advised me that they had not received or cashed a check that had been issued about 2 or 3 years ago. I've since negotiated a settlement with that partner to give them a distribution on account of that uncashed check. In addition, I found a small mathematical error in the report that I filed, so I've corrected that as well in the amended report. Other than that, Judge, I think the report speaks for itself. There's been no change in the amount of cash, the assets of either the receivership entity or the partnership. So I'm simply asking the court to approve the amended distributions that are set forth in Exhibit B1 and B2. And Mr. Hoffman has seen this report, and as essentially the only active party in this receivership, I don't believe he has any issues with the report.
That's correct.
I'm sorry, Mr. Hoffman, I didn't mean to interrupt you. So I want to make sure that I don't see a final order. I don't believe. Let me look.
Judge, I think I was going to upload it right after this hearing.
Sure. Okay. All right. Go ahead and upload it and email it to Rhonda. I see the order from 10/26, but that's from the previous hearing, correct?
That's correct. The new order vacates that order and places a new order in the record.
Can you just make sure that Mr. Hoffman has signed off on the new order, and I'll go ahead and try to get it signed as soon as possible. It would be great if you could upload it today so that I can get it by, I'll be back in the office on Monday and I can sign it then.
Sure. I just sent it to Mr. Hoffman, but I don't think it has a signature block for him. So if he would just add his signature block and send it back to me, we will upload it today.
That work, Mr. Hoffman?
I can do that.
All right. Thank you, guys. Is this it? This is the final hearing, I think.
This is the final hearing on Dallas. There'll be a few more.
Oh, okay. All right. Eventually we'll get this done. All right. You guys be safe.
You too.
Thank you, Judge.
CLC Commercial Roofing versus Cook.
I'm here for CLC, Judge.
And Mr. Clark. So we need to get a trial setting on this case. You
No,
guys
sir. No, sir. You already set it for trial in May. My situation was I've always pled level 3, but we've never gotten a scheduling order. And I just don't want to be in a situation where, we're timed out on discovery because of COVID, and I'm not able to conduct the discovery I feel is appropriate for representing my client, which includes taking the defendant's deposition live, not on Zoom.
May I respond, Judge?
You may.
Yes, Your Honor. One, I hate to be a stick in the mud, but the lawyers should wear coats and ties on these cases. Maybe I'm being old-fashioned.
You are being old-fashioned. It's none of your business, Paul.
Yeah, I don't. It doesn't bother me. It doesn't.
Okay, I think. Okay, doesn't make any difference what I think. Okay, Judge.
That is correct.
Okay, I think people should dress like they're in court. Okay. Secondly, this is in court, and my client's ready for deposition, but right now we do Zoom. You don't get a post because you won't do Zoom. The Supreme Court has said that. He wants to put the trial way off because he wants to be able to do it without doing it on Zoom, and that's not pursuant to what we're allowed to do under the Supreme Court order, and the court can control discovery. And I think he'll get to look right in my client's face and ask him questions. I don't think he's ever met my client. This is a commercial case.
So let me just kind of address a couple of things. So this is CLC Commercial versus Cook, correct?
Yes, sir.
And you said there was a trial setting, but there is no trial setting that I can see. When was it set?
Our last hearing, Judge, I think you said set it for, I think it's set in May.
I don't see. Is that true, Mr.? If that's true, it's just not on the docket.
Let me look on my phone, Judge. I don't know how to switch off the camera. I can tell you that.
Judge, I have May 18th. I thought
that is correct.
Made that oral.
Okay. Well, it's just not in the system, so I have no problem with that. We can reset it to May 18th. That's fine. Or set it to May 18th.
He's got a scheduling order. I think, he never provided a scheduling order to me. So I think I would ask that his request be denied because he's pled it. He never provided it. They're the plaintiffs and they're slow walking the case too much. We've been here before. We had a summary judgment and and they wanted more time to prepare for that, and you granted it. Judge, I mean, it seems like they can take their deposition. I don't know what the rationale is of what it is. I have not been able to understand what the rationale of not taking it, getting it over with, moving it along. And the Supreme Court's taken that into it.
So let's, so the first issue is, do we have a trial setting? Yes, we do. It's, we'll set it for May 18th. I have no problem with doing a scheduling order, but I need to, no one's provided me a proposed one that I can see. Is there a proposed scheduling order?
There is not, Judge.
Okay.
I was told to file, I had to file this motion.
Okay. Did you attach a proposed one to your
I did
motion?
not, Judge.
Okay.
Told by the clerks, or it depends on who he was told by.
Yeah, I don't know who would have told you don't need to. I mean, usually people file a proposed one. It just makes it a lot easier.
No, I was told by the clerk that I needed to file the motion for this hearing to get a scheduling order entered.
You know, some typical deadlines, you know, discovery ends 30 days before trial. But again, I don't really, that's not set in stone. Mr. Clark is right. I do order all depositions, if it's contested, to take place via Zoom or remotely. That is required in the emergency order adopted by the judges, especially with the state of the pandemic. That's going to be my order on this one. So I don't know that that's really set for today, but that is going to be my order until we're no longer in red status here in Dallas County. I don't know what other issues. Do you have a mediator you want to?
That was my issue, Judge, is simply that I wanted to depose the defendant live. And I understand that we're under a situation, and I think that those adjustments should be made, not only for the one side to protect, but also for the other side who feels like that's not an effective way to represent their client. And I am not.
Mr. Cross, I understand that argument, but I have to be consistent. The emergency order says what it does. In every single case that has occurred since the pandemic started, I've ordered them to occur remotely. So I'm not going to treat you any differently than anyone else.
And I appreciate it, Judge, and I'm not asking to be treated any different. I'm just not asking not to be put in a box in terms of discovery deadlines, where should I understand if nothing changes, then my hands are tied. But if something changes and we come out of this and we're able to resume in-person hearings, in-person trials, and that sort of thing, I should be able to depose him in person.
Judge, if I can respond, a couple of quick matters. One, there is something that Mr. Cross hadn't pointed out. My client is in Missouri, and not only the travel during the COVID, but in any time it's an issue. Secondly, if let's say COVID instantly disappeared, we would want the mediation done the day before the day after the deposition, so that he only has to make one trip.
If they're not remote.
Right, and if they're remote, it makes no difference. So we want, so that this is not an issue of trying to harass a out-of-state person, a defendant, to come in for a deposition live. So based on all those things, Judge, and I'm surprised, I don't know, looks like this hearing has to be reset. We don't reach agreement because he doesn't have a proposed scheduling order. We think level 2 is fine. And I think the rules say that it defaults to level 2 if they don't have.
He's requested a level 3. You guys are supposed to reach an agreement as to it. You know, if you don't have an agreement, then I need to make orders. And I guess you're welcome to put anything you want in it, to be honest. I'm very flexible. But if you don't have an agreement, then dispositive motions. So go ahead and write this down, guys. Dispositive motions will be need to be heard 30 days before trial. Discovery will need to be finished 30 days before trial. All depositions and mediations will need to occur remotely until the Dallas County is no longer in a red threat level. So, Mr. Clark, if you want to notice notices for deposition, and he tries to quash it because he wants it in person, then
Yeah, Judge, I'm not asking for the deposition. He's asking for the deposition.
I did never ask for a deposition.
Oh, I'm sorry. I thought he just said he wanted to take my client's deposition.
I thought he said
I've not asked for it.
Okay.
Because of,
Well, I'll
because
take
of the
that
reasons I
he
said.
doesn't have his mind made up. We do.
I just want to be, I want to be transparent here. If this gets to May and you guys are set for trial and you say, hey, look, Judge, and COVID is still happening, which probably still will be, but hopefully it'll get better at some point. It's not a basis to continue anything. You have the right to take these depositions. These depositions will be taken remotely. You have the right to take, to go to mediation. Mediation will occur remotely. It's not going to be a basis to move anything because you decided not to go forward with the deposition. So I wanted to include in the order that any depositions or mediations are to occur remotely until Dallas is no longer at a red thread level.
Judge, and to be fair, I think Mr. Cross may be unaware that a lot of the other judges, including you, give a one continuous. So maybe we get up to May 18th and he wants a continuance. I've opposed more than any other lawyer in this the courthouse motions for continuance, but I always lose because it's their first request.
I'm not going to continue it because he decided not to take a deposition. That's my point. If you're going to
how
do
about
that,
because he hadn't had a previous
you're right. Usually we do reset them, but go ahead and get me an order with that. Anything else you want to include, you can.
Just to get it, try to work out an agreed scheduling order with those limitations the court has set forth today.
Yes.
And
I'll
I'd like
I'll have to throw something together.
if there's a mediator, I'd like to know.
Who did you guys want to use as a mediator?
We talked offline and no names came to mind.
Well, I'd suggest Ray Green, Jay Zaleski, let's see, Oliver.
We can come up with someone, Judge. We don't need to waste the court's time on that.
Do you feel, Mr. Clark, do you feel that's true or not?
Well, I do. Did he hear any names he objects to? I just gave.
I didn't hear any names that I knew.
Oh, I'm sorry. Charles Oliver, Jay Zaleski, Ray Green.
Don't know any of those people.
Okay. All of those are well known by the court and respected by the court. So is there someone you like, Mr. Cross?
I've used Mary Burden for years, but I haven't had a mediation with her in a while. She sold her practice to someone else.
Yeah, but she's still mediating.
Yeah.
Why don't we can do Mary Burden unless you guys agree to someone else. So go ahead and put down.
Depends on the cost, Judge. That would be the only issue. We'd like to keep the cost down, but that may be by and by.
Thank you, guys. Anything else?
Good, Judge.
Thank you, Judge.
All right, you guys have a good day.
Bye.
Let's go. Next, we have Cloud Haven Solutions versus Cruz. Is Mr. Clark here?
Yes, Your Honor. Good morning. I represent the plaintiff.
And I'm here, Judge, for the defendant, Kerry Cruz.
Who is that? Mr. Molinar? I don't see you in our system. Are you an attorney of record?
I filed a motion for new trial and I believe a notice of appearance, but this is on a default judgment.
Okay. All right. Tony, you ready? Tony, you there?
Sorry, yes, Judge, I'm ready.
Let's go on the record on cause number 201171, Cloud Haven Solutions versus Cruz. Counsel, make your appearance.
Matthew Clark, appearing for the plaintiff, Cloud Haven Solutions, LLC.
Ray Molinar for defendant, Kerry Cruz, and movement in this hearing.
Okay. Let's go ahead and proceed.
All right, Your Honor, this is a motion for new trial on a default. The default was taken on August 31st of this year on what was originally a DWOP setting, that the second or third DWOP setting, actually. My client figured this out, that she is actually being served on August 15th. She was checking an old Yahoo mailbox and found a declaration regarding non-military status. She then got on the online system and found out that it was set to be dismissed on August 31st. She sought some advice from a friend, I guess, and said the worst that could happen is that it will be reinstated by the plaintiff. So she took no action, expecting it to be dismissed. The issues that we have are twofold. The actual service itself, my client denies ever being personally served. If you look at the plaintiff's response to our motion for new trial, it says that an agent for plaintiff left the citation and the petition on the door, I guess, or on the gate outside the door, repeatedly knocked on the door and rang the doorbell. Plaintiff's agent for service observed from less than 15 feet away that defendant opened her front door and retrieved the petition and citation. And then it says that they did that 2 days in a row. My client is not aware of anybody that was standing 15 feet in front of her door when she found any papers, and it's much less 2 days in a row. But then if you look to the affidavit of service, it's done by Mr. Clark himself, and he says that he delivered it to the address. It doesn't say anything about witnessing her get it or speaking to her or putting it in her hand. It just says that he does it. Now, if you look back through the file, you'll find that plaintiffs filed 2 motions for substitute service. One of them allowed serving anyone in the home over the age of 16. And then they filed a second one asking to do it by certified mail. But nowhere is there alternative service saying that Mr. Clark himself could just leave it on the door, or somebody. I still don't really know who actually is alleging that did the service themselves. So our contention that is, even if somebody did put it on the door, that was not allowed through any order for alternative service. And my client certainly didn't see anybody standing 15 feet away. The second problem we have is that the default, excuse me, Your Honor, the dismissal date or the dismissal hearing of August 31st was changed to a default hearing on August 25th by a motion for default. And we're not even sure how they alleged that she was served with that, how she even could have known there was a default hearing. I assume they set it to that old Yahoo address that she references in there that she checks sporadically at best. She gets all her emails now through her work address. And the issue at hand is this is basically a non-compete case. My client left their company to go work at another company. She has meritorious defense in the fact that she claims that there was discussions among her and other people at the company, that her position is different with the company, and that the damages are manifestly unjust, arbitrary even. I mean, this is a non-compete clause on a very low-level employee that is, I think, in the neighborhood of $100,000. So I don't think the issue of meritorious defense is even in dispute, but our contention is, 1, she was never served properly. 2, she certainly didn't have notice that the dismissal hearing was changed to a default hearing, and that she has a meritorious defense, Your Honor.
Response?
Yes, Your Honor, thank you. We tried to serve Ms. Cruz for months. And the first time we tried to serve her using a professional process server, we contacted her. She responded to the process server and said, "What do you have for me?" And they informed her that we had a citation and a summons for her. So all the way back to the very first time we tried to serve her, she knew she had been sued. She then intentionally and purposefully evaded service for months. And ultimately, we tried to serve her a dozen times at her house. There's no dispute she lives there. She just didn't open the door. So when I was on vacation in San Antonio, I went there with a copy of the citation and the summons, or the citation and the petition. I knocked on her door, I rang her doorbell, and I stuck the paperwork on her front door. She has a barred window on her front door. And then I stepped back, and I waited for her. And she opened the door, got the material, and went inside. And I did that on 2 consecutive days. So there's no doubt that she got served. You know, I didn't speak to her and say, you've been served, but she got the citation and the petition. And then I sent her an email to her email address, which is in my opposition paper, saying, Ms. Cruz, you were served on July 17 at your home. Your response to the lawsuit is due August 10th, 2020. If you don't respond, I'm going to get a default. So she is also served on the court's portal on all of the default paperwork I filed. So it wasn't in secret that I did the default paperwork. I actually sent copies through the portal to that very same address. And it's not some phantom address. It's the very same address Ms. Cruz used to resign her employment with Cloudhaven. And if we go to the merits of the case, she agreed specifically not to work for Cloudhaven's clients. There is a specific list of clients for which she was prohibited to work for. One of them was CBDMD, her new employer. So there's a very clear contractual basis for the lawsuit, and she violated it. So, you know, I'm in favor, Your Honor, of having cases heard on the merits. I don't like doing defaults. It's a waste of everybody's time, because here we are and she's asking to unwind the default. So it's gamesmanship from a person that wastes your time, my time, and ultimately here we are back to where we should have been here 6 months ago. So, you know, I wouldn't be, you know, if the court grants the motion, that's fine. I think there should be some sort of a deterrent to this kind of behavior, which would be order her to pay the fees that I wasted doing all of these default motions. So that's my position, Your Honor, and thank you for hearing me out.
Okay. I will tell you that in the vast majority of situations like this that come up, and these do come up quite a bit, I will go ahead and do kind of what Mr. Clark has suggested, that I'll grant it and then award attorney's fees. This really does kind of feel like, I would say over 90% of the time I grant them, does feel kind of like conscious indifference, that she knew about it. Mr. Clark reached out to her. It says in the paperwork, he actually went down personally and served her. I mean, she knew that she had been served and she didn't file an answer. And she just kind of took her chances. I mean, it's I mean, if this isn't conscious indifference, I'm not really sure what is, unless I guess she said, haha, I'm not going to file an answer, go ahead and take a default judgment. I guess that would be worse. But it does kind of feel like conscious. I mean, it does feel like conscious indifference. But
Your Honor,
Mr. Clark, I guess if you want to take the option, how much are your attorneys? I'm sorry, Mr. Molinar. How much are your attorney's fees, Mr. Clark?
It's probably a couple $1,000s. It's, you know, it's basic legal work. It's, you know, I haven't added it up, but I'd say it's several hours, 4 or 5 hours. So
give a number.
4 hours at 300 is $1,200. So that's what it would be.
Mr. Molinar.
And Your Honor, I understand what this looks like on its face, and I think my client, whomever she reached out to, I haven't been able to ascertain who told her that it's probably going to get dismissed. At worst, it'll get set back on the docket. And you know, maybe she should have listened. Maybe she should have talked to somebody else. But she maintains that she was not trying to hide from it. That this was not part of an orchestrated plan. But I just find it And I certainly don't think Mr. Clark is misrepresenting anything to the court about going down there on his vacation, but she maintains that she did not see anyone standing 15 feet in front of her door when she got papers. So I don't know what to say about that. I don't know how to reconcile those two things.
So do you want me to deny the motion for new trial or grant it with the $1,200 attorney's fees?
I mean, I want you to grant it with the fees. That I would ask that, I mean, I don't see how it was more than a couple hours to draft a motion for default, but I understand I wasn't there working. So yes, if I have the option, then my client would like a new trial.
All right, so go ahead and prepare, Mr. Clark, an order on the new trial that's contingent on the paying of $1,200. How much time would it take her to pay that?
I mean, I would ask for 30 days.
Mr. Clark?
That's fine.
Okay. All right, just go ahead and get me an order on that. Email it to my court coordinator, Rhonda Pinson, and e-file it as well, okay?
Yes, sir. Thanks for your time.
Thank you, guys. Be safe.
Thank you.
Kimmel versus SND Operating.
Good morning, Your Honor. Carson Runge for the plaintiff.
Good morning, Your Honor. Christina Pierre-Louis for defendant Griffin Holdco.
Okay. Is there anyone else here on this? Brett Smith?
No, Your Honor. This motion that we need heard today wouldn't affect Mr. Smith or the attorney for Lasso.
So it's a little unclear. It says here the hearing type is a motion to quash, but what the clerks provided me was for a motion for summary judgment. What is this, a quash or summary judgment?
Your Honor, this should be a motion for quash. I believe the defendant Griffin's motion for summary judgment is set in December at some point.
Okay.
Yeah, it's set for December 4th, Your Honor.
Okay. All right, let's go ahead and proceed.
Yes, Your Honor, it's plaintiff's motion to quash. This motion stems from DWQs that were sent to the plaintiff's cell phone provider, which would be Verizon. Typically, when we have requests for cell phone records, they are for the day of an incident or for an hour before or an hour after, and typically I have no objection to those. But the defendant Griffin's request to my client's cell phone provider in this case is for 8 weeks of cell phone records. And I've never seen anything like it before, Judge. Plaintiff thinks that is overly broad. It is a fishing expedition. To give the court just a brief background, this is a sheriff's deputy who responded to a report of a smell of gas at a person's residence. When he arrives, he starts evacuating people. As he's evacuating people, he starts succumbing to the effects of that gas, which ended up being hydrogen sulfide gas, the most poisonous gas in the oil field. He called his chief there on the day of the incident, reported his symptoms. He was then carried off in an ambulance, carried to a emergency room in Rains County, Texas, intubated, put on a helicopter, and kept in a coma for 2 days. So that's kind of the situation that we're dealing with here, Your Honor. I have no problem with a scope that provides for my client's cell phone records for the day of the incident. I think it's a little overbroad, but I'm happy to give them to him. But 8 weeks, Your Honor, is just the epitome of a fishing expedition. We ask the court enter an order preventing that disclosure.
Response?
Yes, Your Honor. Thank you. Just in response to Mr. Runge's argument, we do believe that based on the alleged injuries presented in this case of brain injury, confusion, depression, we feel that Griffin and any designated expert should be allowed to see how is he using his telephone? How much is he texting? All these things. If he's alleging these injuries, we should be able to see what is his activity like. Additionally, we need some evidence prior to the incident, some evidence after the incident. Your Honor, also, the plaintiff has already testified to different conversations he had on his personal cell phone on the day of the incident. So he would like additional information of who was he calling other than his boss and Mr. Rojo, which he testified. He also testified to what was said during those conversations. And now they're saying this information is privileged, that we're not allowed to see anything other than this 1 hour before, 1 hour after. These cell phone records are relevant. The courts have already said that they allow a limited scope of cell phone records. We've asked for a limited scope. And Your Honor, I mean, if you believe 8 weeks is too long, we believe 2 weeks before, 2 weeks after the incident is sufficient. But we believe that we're entitled to more than just an hour before, an hour after the incident.
Brief response, Judge.
May.
The plaintiff is okay, and we agree to give them the day of the incident. The only evidence or the only argument from counsel is he's testified to phone calls of the day of the incident. Okay, I don't disagree. So let's give them the day of the incident. Then the second argument of why they need 8 weeks and now 4 weeks is that my client's alleged a brain injury and depression. I know that I'm just a simple country lawyer, Judge, but I don't know of any scientific studies that say depressed people don't text, or that text messages or phone usage is somehow indicative of full functional capacity. And I've never, the day of the incident, Judge, should be more than plenty based upon the arguments of counsel.
I usually kind of do what you said, Mr. Runge, which is either an hour before, hour after. This one is a little more complicated, so I will do the full day. It's a creative argument about the head injury, but I agree that I don't think it's now if during discovery there's some allegation about a particular text message that came up, you know, or as the defendant or if the plaintiff testifies, I can't text anymore, I don't know how to use the phone or something, then I may expand the scope. Is there any testimony like that?
Not that I've seen, Your Honor.
So I am open to revisiting it if something like that comes out. But
Your Honor, just so I understand, you're granting us the full day, not just the hour before, hour
correct,
after.
correct, full day.
Thank you, Your Honor.
And
Your Honor,
can you go ahead and email my court? I'm sorry, Mr. Runge, I didn't mean to interrupt you.
Judge, I just want to give the court somewhat of an update on where we are. I think since we last had a hearing in this case, I have survived COVID-19, which put me down for a few weeks. But in any event, we are going to file a joint motion for continuance, Judge. Right now, I think we're currently set for February 2nd. We have done a lot of work. We've taken depositions. I think Christina, probably 3 or 4 since our last hearing, would be my guess.
That sounds about right. Yeah.
Yeah. And, but there's still a lot to go, Judge. And so we're going to file a joint motion with an agreed scheduling order for, I think, a trial date sometime in September. I saw at least something that suggested that maybe the courts in Dallas are not even considering trials in February as we speak now.
That we are or we're not?
That y'all are not?
So I'll give you kind of an update on that. I don't think it'll affect your case, but we just had our first, I tried the first remote case in Dallas County. So I've done one remote jury trial for all of Dallas County since the pandemic, and that was this Tuesday. My intention is to try another one probably around February, so about the time that you guys, but I don't know that a case of this complexity would probably be my next case I would want to try. And so I will say, you know, now that I've been through it, that what we're trying to get to is doing hybrid trials where we can do jury selection remotely and the trial in person. The numbers are just so high in Dallas County right now, we can't even do that. And so, you know, but this case, I would feel comfortable doing it as a hybrid. I would not feel comfortable doing one at this point remotely. Now, if it's next September and we're still doing cases, still in the pandemic, God forbid, then we probably will do them remotely. But at this point, so anyway, bottom line is I have no problem moving to September. If you want to, if you both agree, if you don't agree, then we can have a motion for continuance, and I can hear all the arguments on both sides. But it sounds like, isn't there another attorney involved in this case?
There's 2 other attorneys. One represents Lasso, Judge. The other one represents entity called Race Systems. I don't think that, of course, the major parties are here at this present hearing, Judge.
So what I would suggest you do is file an agreed motion for continuance since they're not here. Otherwise, I could just reset it. And I don't have any problem, in theory, resetting it to September, given this particular case. But I'd want to make sure that everyone's agreed to it.
Absolutely, Judge.
Yes, Your Honor.
And then get me an order on this particular motion as well today, okay?
Yes, Your Honor.
All right, thank you so much.
Thank you. Your Honor.
Y'all be safe. Hey, Rhonda, what's the status of can you come in here? Megan, can you grab Rhonda? What's the status of our prove up? Yeah, I don't see that it's canceled.
But nobody showed up. Let me just check real quick, because they might have just,
Emailed you or something.
yeah, let me check.
So it would be kind of interesting to Megan, to watch this prove up. The plaintiff, the guardian ad litem, is one of the most entertaining lawyers. Very, very good lawyer, very, very good lawyer, but also very, very entertaining. So it'd be kind of fun for you to be able to watch her. Remember, 2 o'clock, we have the picture.
No, Judge, they're gonna be resetting it. They thought somebody had already called the court. So.
Okay. Thank you. Okay, Ashley, Tony, Julian, I just wanted to let you know that the prove up was canceled. So that's our last hearing for today. We do have, I want to remind Ashley and Julian, we do have our pictures at 2. Are you guys both able to make that?
Yes. Yes.
Any questions before we finish up? Ashley, is this your last day?
You know, I wasn't sure whenever we would have the last day. I mean, I still have classes next week, so I would assume I'd be able to come in on Friday, and if you had any hearings on Tuesday.
Next Friday is Thanksgiving.
Oh, well, then never mind.
You usually come in on what, Fridays and Mondays, is that right?
No, it's Tuesdays, but I can only be here after 10:15, and normally you're pretty much done by then, so it works out to just Fridays.
Did you get to watch any of the jury trial?
No, I didn't.
Oh, that's too bad. That was really good.
Is it on YouTube?
Yeah, it's on YouTube. It's, yeah, it's, Julian did a great job helping out with that. But yeah, it was a really, really interesting, and it's all on YouTube pretty much, or some parts we couldn't include on YouTube, but most of it's on YouTube. So, so next Tuesday, I'm not going to have any trials or hearings, and then Friday. So with this, and then the week after, do you have finals, or what's your?
I have finals on the 3rd, so yeah.
So do you want this to be your last day, or what are your thoughts?
You know what? I'm going to try to make it next week because I think I've got a lessened schedule, but I'm not sure which particular days.
Yeah, the only day we have anything is Monday.
Oh, okay. Yeah, never mind then. I guess it is my last day.
I enjoyed working with you, and and Julian, what about you? I know we talked briefly about you might come back for a few more hearings, or?
Yeah, I'll be continuing through December.
Okay. In our hearing docket on Monday, I don't know if you noticed, but it doesn't start until 10:15. So just don't wake up at 9 and then, hey, there's no hearing. But I think you usually come in the afternoon. We may not have anything in the afternoon either, because we have a pre-trial hearing, I think, and a temporary injunction. Temporary injunction starts at 11, and I don't know how long it's going to last. So you might want to just, sign on to the Zoom, and if it's not there, then, or what were you going to say?
I won't be here next Monday due to work obligations, but I'll start the Monday afterwards on the 30th.
Okay. Yeah, we'll have a normal docket that day. Okay, any other questions? Any questions, Ashley, or since this is your last day? But I guess we'll see it too, but.
Yeah, no particular questions.
Well,
sorry,
good luck with
it. My face is still a little bit frozen.
What'd you say?
My face is still a little bit frozen on this side, so.
Well, good luck with the DA's office. I hope that all works out. And Julian, again, a great job on helping out with the trial. And other judges have now reached out to me and are planning on trying to do some virtual trials. I don't know how many. And anyway, I will see you guys at 2:00.
All right, bye.
All right, bye-bye. And remember, it's a different link. I sent you a different link.
Okay.